morning, Your Honor. May it please the Court, I'm Brendan Leary. I'm a counsel representing Matthew Quinn Mason, the petitioner in this matter, and we're asking this Court to vacate the judgment of the District Court wherein Judge Bailey dismissed Mr. Mason's petition to vacate his conviction under 28 United States Code, Section 2255. Your Honor, a very quick housekeeping matter, and I apologize for this error, but I'd like to correct something in my brief. At the bottom of page 16 and the top of page 17, excuse me, I quote, there's a block quote that I attribute to a United States Supreme Court case, Williams versus Taylor. Unfortunately, somehow in the drafting, editing process, that's an incorrect attribution to that case, Your Honor. I got that from a treatise, the Criminal Practice Manual Update, Chapter 6.3, entitled Pretrial Failure to Investigate. It's published by Thomson Reuters. It's clearly not binding precedent, Your Honor. It's a persuasive secondary source. It's a treatise that talks about the Williams versus Taylor case. I apologize and regret that error. That doesn't change the legal standard here. The legal standard is simply under the two-part test under Strickland versus Washington, whether the underlying trial counsel's performance was ineffective under the Sixth Amendment. It's a very standard and well-known legal standard here under Strickland, which is the two-part test as to whether the underlying trial counsel's performance was defective, and that is simply whether it fell below an objective standard of reasonableness. And then the second issue is obviously the prejudice prong.
Before you leave that, let me just point out one other thing. When you do the table of contents, you're supposed to tell us on what page each witness's testimony begins. You know, just to say transcript of testimony 1 through 500, that doesn't help us when we try to locate individual testimony. I'm just telling you why you're bringing up those things. It would help us in the future.
Your Honor, just so I'm clear, are you saying that when we refer to like Mr. Klingsdale's testimony?
When you do your joint appendix, you do an index, and this says transcript of day 1, pages 39 to 134. But when you cite the testimony of an individual witness in your...
You have to break it out by witness.
You need to break it out.
I apologize,
That's
Your
okay.
Honor.
Go ahead now. Let's get to the merits.
Thank you for that. And I didn't do that, and I regret that. The legal issues are simple in this case, in our view, is that this court has to conduct a de novo review and determine whether the underlying trial counsel's performance fell below an objective standard of reasonableness, and whether under Strickland, the second part test is whether that performance prejudiced Mr. Mason. And
we had an evidentiary hearing on that.
Indeed, Your Honor. This court vacated...
Who tell me the testimony that was taken?
Certainly. At the evidentiary hearing about a year ago, Mr. Mason testified, the petitioner. His underlying trial counsel, Mr. Garrett, testified. And a lieutenant from the Eastern Regional Jail, Eugene Bittinger. We also...
He was the chief correctional officer at the institution.
He wasn't the chief, Your Honor, but he was in charge of the...
He was a correctional officer there.
Correct, Your Honor. And he was able to provide testimony, authenticate records and exhibits. The government introduced several exhibits. We introduced several exhibits. The issue at the evidentiary hearing, Your Honor, just so the record is clear, there was this court, when it remanded for the evidentiary hearing, there were two issues at play, whether that Mr. Garrett failed to communicate plea offers to Mr. Mason, and then the second issue was the housing arrangements. We have not pursued in this appeal, Your Honor, the first one about the failure to present plea offers. The only issue that we've presented here is the fact that Mr. Garrett, in our view, didn't move to continue, didn't investigate the supplemental 404B notice that was supplied by the government approximately 2 days before the start of the trial, that for the first time fleshed out the testimony of Mr. Klingsdale.
So the evidence with respect to the cell arrangements,
Yes, Your Honor.
would have been impeaching evidence?
We believe it would have been fatal impeaching evidence, Your Honor, because...
Understandably, but isn't it unusual that impeaching evidence becomes the basis for a new trial? I think you'll find a lot of statements in the precedents that impeaching evidence is seldom, if you fail to locate a witness, that's a pretty big deal. If you fail to locate a very relevant witness and you don't really try something, that's fine. But impeaching evidence is very seldom used as a basis for a new trial.
In isolation, Your Honor, I agree with that. However, I think the court, in your question, hit on a very important point, which is how relevant or how crucial that evidence is. And in this case, the government had to prove at trial that the actions that Mr. Mason took that evening were to retaliate against Mr. Clinkscale for his testimony against a co-defendant. And the issue in this case, Your Honor, was intent. In fact, the government acknowledged in its opening statement to the jury that the issue in this case was intent. And Mr. Garrett, to his credit, talked about that a lot in his closing argument, that the issue here was intent. The government had to prove in each one of the elements for each three counts in the indictment that the actions that evening by Mr. Mason were with the intent to retaliate. And the only evidence, only direct evidence, that the government presented at trial to establish and meet its burden of intent was Mr. Clinkscale's testimony, and the crux of that testimony.
But what are we supposed to do? I mean, we earlier remanded for an evidentiary hearing on the point. The district court takes testimony and holds the evidentiary hearing and then comes up with a finding, which is dead on point on the issue of prejudice, and says, quote, the testimony elicited from the evidentiary hearing tends to corroborate Clinkscale's testimony, so, there's no a prejudice here. And then he makes a specific finding on page 750 of the appendix. Petitioner and Clinkscale were cell neighbors above and below in the same pod section, A5, for a 10-day period. And then he goes through with how each of the three incidents could happen. Now, I know everybody tries to present everything as a mixed question of fact and law when the findings below are against them, but this seems to me about as close to a factual finding as you can get, and we'd have to almost rule it clearly erroneous to judge in your favor.
Well, Your Honor, I would ask the court to do that.
The rule is clearly erroneous.
Well, we're asking the court to vacate so that, actually, I guess the remedy that we're seeking here is for the court to grant the petition. Perhaps I misstated it in my...
To what?
To grant the petition, because Judge Bailey dismissed the petition and held, as you're correct, Your Honor, he determined and made a finding that there was no prejudice.
But in order to dismiss the petition, we'd have to conclude after an evidentiary hearing that the district court's finding of no prejudice was clearly erroneous.
Well, we would submit that I think that the district court's finding on that score was erroneous.
I thought your position was it was impossible.
Well, there are certain instances in his testimony, Your Honor. He talks about that there were three specific interactions at the Eastern Regional Jail between Mr. Clinkscale and Mr. Mason that forms the basis for the intent to retaliate, one of which absolutely is impossible, Your Honor. And that brings me to...
It's impossible is clearly erroneous.
I would submit yes, Your Honor. I think it is. And I think
thought that's what your position... I don't understand why you were kind of dancing around
in terms of
answering that question.
I'm not sure I'm following you, Your Honor. I apologize.
I thought that, for example, when the conversation occurred between Mr. Clinkscale and Mr. Ray, where they were outside the window.
Correct, through the window, through the cell window.
And he says that occurred the night before trial.
It didn't.
And that's your position is, as I understand it, that's impossible.
Yes.
For your client to have been standing there.
That's correct.
At that location the night before trial.
The records reflect that. The records show that, absolutely. The records and Lieutenant Bittinger's testimony at the evidentiary hearing support that. That did not occur on either August 29th or August 30th, 2008. Right. That's absolutely correct. Now, I think the district court talks about how it could have happened another day, but that was never presented to the jury, and that's where we believe the prejudice here is.
And what was the third one?
Well, there were three, Your Honor. The first one was there was a note engraved in a bar soap.
I know. What was the other one that we have?
The third one was Mr. Clinkscale testified that when he came back after testifying against Mr. Ray that evening, as he was coming into the A5 pod, there was a group of cellmates or other prisoners there who were loudly
But
proclaiming.
Klingskill said he saw
That's an important
them.
distinction,
And-
Your
and-
Honor.
And in your position, that's impossible?
That is impossible, because at page 65, Your Honor, of the joint appendix, which is Mr. Klingscale's testimony, he says that I want to be clear, he doesn't say that he saw him, he says Mr. Mason was there. Now, Lieutenant Bittinger testified that the way the cell pods are arranged, you can't see into an adjacent pod. We know from the records that Mr. Mason was in the shoe, in the adjacent pod. So Mr. Klingscale could not have seen him. Now, could he have heard? Yes. I think Lieutenant Bittinger's testimony said, and I think the records and the layout of the jail suggest that perhaps he could have heard, but the testimony led the jury to believe that he saw Mr. Mason at the entry of the pod.
All right,
That is impossible,
I
Your Honor.
understand that. Let me ask you one other question. I'll try not to interrupt you anymore.
No, I'm here to answer questions.
Did the court, our court, ever resolve the question of credibility as to what your client told his lawyer when confronted with the evidence against him that this guy was going to say he'd retaliated in these events that occurred? Was that ever resolved as to what, in other words, whether or not there was deficient performance?
Your Honor, I don't believe it was, and that's one of our arguments as to why there was deficient performance, because Mr. Garrett and Mr. Mason, I think, both testified at the evidentiary hearing that when late disclosure came, there was never a conversation, that Mr. Garrett never shared this information with Mr. Mason, such that Mr. Mason could say, hey, I'm in the shoe, it's impossible for these things to have occurred. Mr. Garrett indicated, I think, at the evidentiary hearing when he testified, he said that he had a conversation after the jury had been selected when Judge Bailey
But
addressed
that's
the
never
issue.
resolved. Those discrepancies are never resolved
I don't
by the
believe-
court.
No, Your Honor, I don't believe the district court addressed that. I think the district court's focus, going back to Judge Wilkinson's inquiry, is the prejudice prong. And I'll concede, I think that is our harder burden here.
But the real question here, you can look at the forest or you can look at the trees here, and the real question here is, were Mason and Klingscale sufficiently close to one another that Mason was able to observe Klingscale and his cell and evidence that Klingscale had testified against Ray. And the question is, were they? Was it? Maybe the specific date is not 100% correct, but the question is, was there sufficient proximity between Klingscale and Mason so that Mason was able to observe Klingscale in sufficient enough detail that he was able to pick up that Klingscale had earlier testified against Ray. And what the district court is saying, I think at the ultimate conclusion is, yeah, these people were close enough, and Mason was able to get to form an opinion as to Klingscale's intent here, and he was able to piece together the fact that Klingscale had.
We know from the records, Your Honor, that there was a period of time where Mr. Mason and Mr. Klingscale, approximately 10 days in August of 2007, there was a period of time where Mr. Klingscale and Mr. Mason were in the same A5 pod at the Eastern Regional Jail. There's no doubt about it. The records speak for themselves. There was a 10-day overlap. However, the problem with the cross-examination by the underlying trial counsel was he didn't zero in. In fact, I would argue he didn't really zero in on any of these three interactions. He only kind of focused on one, the facilitation of the discussion between Mr. Ray and Mr. Klingscale through the window, the cell window. He didn't even touch on the soap note or the instance where he was coming back into the pod after testimony. And I think that the records and the dates, and that's the key inquiry, I believe, that he wasn't able, he could have pinned him down as terms as some of these were, in fact, impossible. I think the district court talks about it in its order that with the SOAP note in particular, perhaps Mr. Clinkscale just misremembered in terms of in terms of the facilitation of the meeting through the cell window. Perhaps he just misrecalled what date it occurred. But I would argue that the dates here are crucial to the cross-examination and the impeachment, because I believe Mr. Garrett could have led Mr. Clinkscale down the primrose path in cross-examination and gotten him to as what defense counsel calls an aha moment in front of the jury, where it couldn't have happened on those dates. And I think that's the key problem here. The dates, he didn't talk about those dates, and if he had known the layout of the jail, then he would have known that the conversation, when I say he, Mr. Garrett, he would have known that this allegation that he had talked, when he came back in after testifying, that he couldn't have seen that to have occurred, that it was an impossibility.
That's why I'm a little bit frustrated. I'll ask for a little additional time. That's why I'm a little bit frustrated that this credibility decision hadn't been resolved, because if the defendant has only said to him, man, that guy's lying, and that's it, I'm not sure a defense lawyer would have rendered ineffective assistance of counsel by not asking for a continuous and time to investigate that. On the other hand, had he given him details and said, that can't be, we weren't even in the same block or plot or whatever.
I think there are
that's a different situation.
I think there are two instances, just real quick, and that is that I think the testimony at the evidentiary hearing indicated that from both Mr. Garrett and from Mr. Mason that this discussion didn't occur, that they didn't have time. Now, the record reflects that after the district court ruled, there's a pause where Mr. Garrett consults with Mr. Mason. Now, what the substance of that conversation is, I think that Mr. Mason said that it didn't happen and that he was in the shoe. The only thing I can point out is that when Mr. Garrett filed a motion for a new trial and for a motion for a judgment of acquittal subsequent to the verdict, he did for the first time lay out that Mr. Mason was in the shoe. So at the evidentiary hearing, both Mr. Mason and Mr. Garrett testified that for the first time they discussed this was after the jury had been impaneled and the district court took a short break before opening statements.
And when
Too
did the
late in our
government
view.
provide this information to the defense?
I'm sorry, Your Honor?
At what stage, what point did the government provide this information to the defendant and his counsel?
2 days before trial, Your Honor. The jury was picked on Monday starting at 1 o'clock. On Saturday, the supplemental notice was e-filed. I've reserved some time for
there was a vigorous cross-examination of Clinkscale at the trial.
Your Honor, I would disagree with your characterization of vigorous.
You're not going to give Mr. Garrett credit for anything.
No. In fairness, Mr. Garrett's a friend of mine, and I don't want to beat up on Mr. Garrett.
Maybe,
That's not what I'm here to do.
As of yesterday.
I think that Mr. Garrett's lack of preparation hampered his effective cross-examination of Mr. Clinkscale. And in particular,
He cross-examined him about each of the incidents, but more than that, he questioned during the cross-examination about why he'd never told anybody he was incarcerated with Mason prior to that time. And then he questioned Clinkscale also about the deal the government was providing for his testimony. So he did his best to shake Clinkscale's testimony, and he said, wait a minute, this is coming up. You haven't told anybody prior to this time that you were ever incarcerated with Mason. This is a bunch of hooey.
I think Mr. Garrett's cross-examination, my reading, Your Honor, my reading of Mr. Garrett's cross-examination of Mr. Clinkscale was focused on three things. Number one, that his statement under oath at trial was inconsistent with his grand jury testimony. Secondly, he did inquire briefly about the facilitation of this meeting between Ray and Clinkscale in Mason's cell, but he didn't get into the details of it. Mr. Clinkscale just said, well, we were talking through the cell and the jailers didn't see us. And then Mr. Garrett then turned to another matter. The final issue of the cross-examination Mr. Garrett focused on was the evening of the incident when Mr. Clinkscale fled and then called the police. The statement he gave that night to the police was different from his testimony at trial as to the events that occurred with the shooting, not at the jail. So,
Was there any plausible alternative motivation or suggestion of why anybody would have fired 5 shots at Clinksdale?
well, I think the government's theory, Your Honor, was that,
I mean, from the defense.
no, I think the defense...
Not that you had a burden, of course.
Right. I think the defense's theory was that there were 3 individuals in the car, Mr. Latta, the co-defendant, and then another gentleman who to this day has never been identified.
And Mason.
And Mason, that's
Right.
correct.
Okay.
And I think that the defense at trial was these other people were doing the shooting. Mr. Mason
But-
was just driving.
Yeah,
So
but,
what
but
was
that,
his
that would have been
intent to
sufficient to
retaliate?
convict him.
Excuse me?
Even if it were true that Mason was simply the wheelman,
Mm-hmm.
if he had knowledge of what the enterprise entailed, that doesn't negate his guilt, right?
No.
He doesn't have to be the shooter. He doesn't have to be.
I agree with that. I
Okay,
agree with that.
so-
Mr. Latta testified that Mr. Latta, was shooting for no reason. Mr. Latta...
And the jury clearly didn't believe that.
I agree with that.
Yeah.
And Mr. Latta
Don't
also...
shoot somebody for no. Well, some
Right.
people do.
Well, Mr. Latta also testified that when they were in the car following Mr. Clinkscale, or it might have been after the shooting, that this third gentleman, Tank, made some comment about how he told on Esco. Now, that's a hearsay statement that wasn't objected to. Nonetheless, it came in. So there is that statement. Now, does...
So there are 2 statements, because didn't Latta say he testified against me?
Your Honor, I would have to defer to the court. My understanding of Mr. Latta's statement at trial was that we were shooting for no reason, and that he told the jury that that Tank made a reference to he snitched on Esco.
Right, that's in there. I
And-
thought he said something he testified against me.
Well, no, Mr. Latta, there was...
Latta quoted Tank as saying that, I think, but I'm
Well,
looking back.
there may have been, Your Honor. But going back, Judge Davis, to your question, that was Latta's statement. Now, that was, I think, to why he was shooting. Now, why is Mr. Mason driving?
He's aiding and abetting.
Well, I mean, that's certainly the government's theory, but I think that the defense at trial was, well, they haven't proved that it was Mr. Mason's intent. Perhaps it was Tank's intent, or perhaps it was Mr. Latta's intent. He pleaded guilty, so obviously that was his intent. But the defense trial was they didn't prove intent, and that his
But they've
actions...
got to, as an element, they've got to tie this retaliation to particular testimony. I don't mean details of testimony, but to a particular trial. Isn't that right?
I'm not sure I'm following you, Your Honor. Could you repeat
The
that?
indictment alleged that the shooting was in retaliation for
Yes.
testimony at a particular trial.
Mr. Ray's trial.
Right, so they've
Correct.
got to tie
Yes.
this shooting to that particular trial, which is why they've got to,
Yeah.
show what it is, why it is they're shooting. It's because of Clinkscale's testimony at this particular trial, and not for some other reason.
Right.
Because if it's for some other reason, or some other trial, or testimony against another person, then you can't establish the element
I agree with that.
of the indictment.
I agree with that. I've reserved some time for rebuttal, and I'll be happy to answer further questions. I think my time is up.
All right, let's hear from the government.
May it please the court, my name is Erin Reisenweber. I'm an assistant United States attorney, and I'm here on behalf of the appellee, the United States of America. It's the United States' position that the district court was right on in focusing its order and its decision on the prejudice prong of Strickland. And as this court is aware, the Strickland case set forth that if the defendant does not meet his burden under the prejudice prong of Strickland, then the reviewing court need not consider the remaining requirement under that Strickland case. I'd like to begin, Chief Judge Traxler, with addressing one of your last statements regarding the particular trial of Mr. Ray. I believe that the elements of the offense require that the United States only establish that there was an official proceeding. at
You didn't
which,
specify which one.
correct, Your
Was
Honor.
any official proceeding.
An official proceeding.
Well, you did it in the
So-
indictment.
Yes, and we did in the indictment. I think in this case,
So let me just ask, so when Mr. Latta testifies that Tank came out high styling over something, I'm saying, talking about this person had told on him in some certain something, and he asked Mason to follow him. If the jury believed that part, that's sufficient to establish the element of testifying in an official proceeding?
I don't think so. I don't
Okay,
think
that's
that,
my
I agree
point,
with you.
Is that this guy has said two different things. Latta has said two different things. One, let's get him for testifying against me, and two, let's get him for testifying against ESCO.
I agree
And
with
so-
you, Your Honor. No, what Mr. Lotta testified to that day is not, I agree, sufficient to have established.
Which makes it become, because he's saying two different things or two different people, now this testimony about what Clinkscale was said or what involvement the defendant had in this case with Clinkscale becomes more important, because he's the one that's got to, you got to strengthen his testimony that
I
it's
agree.
this case that everybody's talking about.
And Mr.
Former case
Lotta,
of Phillips,
I'm sorry.
the former case involving Ray, I'm sorry.
Yes. And Mr. Lotta was impeached in this case with an audio recording, which is not a part of our flat record in this case. And that audio recording was played for the jury. And that audio recording was taken the morning after the shooting. And it was in that audio recording that the jury heard in Mr. Lotta's own voice and his own words say, Mason told me to shoot at him, and that Clinkscale had put ESCO in jail for life. That did only come in for
Put who?
impeachment. Mr. Ray, Cecil Ray's street name, his alias is ESCO. And so the morning after the shooting, Mr. Lotta is indicating he knew the alias of Mr. Ray, that he had heard Mr. Mason refer to Mr. Ray as ESCO in the car, and said that Clinkscale had put Mr. Ray in prison for life.
Mason
Mr.
said that.
Correct, and Mr. Ray did receive a sentence of life in prison. So there was accurate information reflected in
So tell
Mr.
me how that came in before the jury in the form of Mr. Latta's statement?
That came in before the jury as impeachment with a prior inconsistent statement.
And who's
When
impeached? Is the defendant impeaching him?
I impeached my own
You
witness.
impeached your own witness.
I did,
Okay, now,
I did.
does that come in for its substantive value?
It did not come in for
Just for
substantive,
pure impeachment?
For
So
pure
the jury
impeachment.
can't consider that
correct.
in determining guilt or innocence as far as substantive evidence.
Correct. And the judge made the jury aware of that, and I reiterated that in my closing argument as well, that it was only for impeachment.
It's interesting you chose to put Latta up under those circumstances.
I had interviewed him
He
just as
surprised
an
you?
aside, and I was surprised, yes.
You do what you got to do.
I did what I had to do.
But the effect now is that Latta's X'd out, right?
Yes,
Because the jury can't infer the opposite of what he said on your direct from the impeaching tape, right?
correct.
So now what do we have other than Clinkscale?
I believe that, first of all, and other than Clinkscale, the jury saw video surveillance tape from Walmart. They watched Mr. Mason and the true name unknown individual approach Mr. Clinkscale. Walmart has unbelievably placed cameras which captured not only the interaction within the store, but actually captured the two men leaving, following Mr. Clinkscale, getting into their vehicle.
Which two men?
Mr. Mason was driving the vehicle. Mr. Lotta was seated in the front passenger seat, and he never went into Walmart. He remained in the vehicle the entire time.
Latta did.
Correct. And then the unnamed individual was in the back seat. And you saw the jury watch the three of them make a U-turn in the Walmart parking lot to begin to follow Mr. Clinkscale.
And no question Mason's driving.
No question Mason is driving. Also, I'm sorry, I think that the judge's instruction that intent can be inferred, it's not required that it be proven through direct
Was there
evidence.
any other motives suggested for, at any point in time for the shooting of Mr. Clinkscale?
No, and Judge Davis asked that earlier.
I was
and
very interested in the answer to that
There were,
that
was,
question. I mean, what other motive was brought up other than retaliation?
there was
snitch?
no other motive. Mr. Lotta testified that he shot at Mr. Clinkscale because he was hallucinating off of boat, which is marijuana dipped in PCP. And that was the only reason he gave for shooting at Mr. Clinkscale.
Was there ever any evidence as to whether or not this person, Tank, had ever been testified against?
No, there was no
Do you know his name?
evidence. We still do not know his name. There was no evidence that Mr. Clinkscale has ever testified against anyone else in any
Testify to
proceeding.
that effect?
I'm sorry?
Did he testify?
No, he did not. He did not testify to that effect, except that I can put forth that he did testify that from the time of his testimony in the Ray trial until March 2008, he himself was incarcerated.
But the defense never suggests that there's any other reason to be shooting at Clinkscale
No, Your Honor,
other than his testimony against Esco.
that's correct. And so the United States position is that
There's no question that Mason actually fired the shots.
Mason did not fire any
I mean,
shot.
but he was driving and following Clinkscale.
Correct, he was the driver.
He was the driver. And
And
there's no question about that.
There's no question about that. Mr. Lotta testified that Mr. Mason was in fact driving the vehicle, and that video surveillance, you're able to discern the clothing that the individuals have on when they leave Walmart, and then you can see who gets in the driver's seat of the
So-
vehicle.
So the only question is whether he did this as retaliation against Ray, or as a retaliation for the testimony against Ray.
Correct.
And as to that, there was no other motive for the shooting suggested?
No, Your Honor. I would like to direct your attention, though, and it is in regard to the second incident about which Mr. Clinkscale testified, and that is his communication through the window with Mr. Ray the night before trial. If you look at the joint appendix at page 64, Mr. Clinkscale is not the one who actually testifies that that occurred the night before trial. I, in fact, was when I asked a very leading question of my witness on direct examination. I am the one who says, on the night before Mr. Ray's trial. Granted, the witness agreed with my leading statement.
Well, you wouldn't have just pulled that out of the air.
I did
You
not.
wouldn't have just made
I-
up a date unless you had some reasonable basis to.
Correct, and he had
Reconsider.
told me that during a pretrial witness interview, which is why I worded my question that way.
What the district court holds an evidentiary hearing, and it goes through these three different instances and everything, and, naturally, it would be up to the defense to try to cast doubt on those, but is the ultimate question, even apart from the details, whether the petitioner and Clinkscale hung around each other enough and talked to the same people enough, because that Clinkscale would I mean, that that Clinkscale would have, that Mason would have an idea of what Clinkscale was up to. I mean, when you're talking about a jail environment, you're talking about information that's swapping hands all the time, and pretty much people know what's up if they're in close proximity to someone else, and they particularly know what's up in terms of who snitched on whom, because that's an offense against against one another, and snitches are among the most endangered people in a jailhouse environment. And so if, regardless of the specifics of the incidents, if the gist of the incidents and the gist of the credibility findings were that these people were together for a significant amount of time, and that and that they had some of the same friends and they talked to the same people, they knew what was up. I mean, that seems to me the larger point that's at issue here. These people weren't in different facilities. They were around each other. They were talking to the same people. They observed each other. And in a jailhouse environment, you know who snitches on whom. That's hot stuff. That's a hot commodity in a jailhouse environment, because those folks are regarded as real traitors. And they're marked men and women for that kind of testimony. And that's kind of the reality of it. And I think that's what the district court was picking up on.
I agree, Your Honor, and that's where I disagree with appellant's statement that these jail records were fatal in not using them to impeach Mr. Clinkscale, because in fact, had Mr. Garrett obtained those records, they would have confirmed that Mr. Mason and Mr. Clinkscale were incarcerated together for a 10-day period in August of 2007. At the joint appendix, beginning at page 598, the photographs, which came out terribly in the joint appendix, but were beautiful at the evidentiary hearing, I will just explain to you the layout of this pod. It's a 16-man pod, and you enter the area. There's a common area with almost like steel picnic tables, and there are cells on the bottom tier and cells on the top tier. And the 16 men that are in this pod socialize together. They have a common space.
If you're in the same pod, everybody knows everybody else's business.
I agree, Your Honor. And they also, Lieutenant Bittinger testified at that evidence.
And they were in the same pod, were they not?
Mr. Clinkscale was on the second tier, and Mr. Mason was right below him on the first tier. Their doors remain open to their cells, and they are free to move about.
And they shared a common area.
Correct. They share a large common area on the first floor.
How
So
far
it's-
had they driven that night before the shots were fired?
I would estimate it's about a 2-mile drive, including a small portion that was on Interstate 81 for about a half a mile. Mr. Clinkscale did testify he tried to evade and was even speeding at one point through a 25-mile-an-hour area, but they continued.
He knew he was targeted
Yes,
by the time he left the Walmart.
he recognized Mr. Mason from that period of incarceration, and he did tell that to the police the morning after the shooting. He said he knew the driver from their period of incarceration together. So it's the United States position, and I know that Judge Wilkinson, you are familiar with this case, that the 2 prior times it has come up on both direct appeal and after the certificate of appealability, you have been a part of those panels. But the United States position is that Mr. Mason just can't sustain the burden of Strickland as to either prong.
Well, Yeah, but, I mean, we did, you know, it's not as if we dusted off the case. We sent it back for an evidentiary hearing. Let somebody listen to these different people who were actually there, and sort of find out what is it. And so ultimately, he comes out, look, this, from what I've heard, the testimony elicited here corroborates Clinkscale's testimony. That's what he comes up with.
And for those reasons, we ask that you affirm the district court's decision in adopting the report and recommendation that Mr. Mason's petition be dismissed.
Why'd you make the late disclosures?
That's the day
That
he
brought a
told-
smile to your face, so there must be an interesting story behind that.
Mr. Leary predicted that that is a question I would be asked today. That was the day that Mr. Clinkscale told that part to me for the first time on that Saturday, and I immediately disclosed them. Mr. Leary and I, as an aside, were both law clerks together for the late Judge Broadwater, so this has been a nice experience for us to argue against each other today. Thank
Glad to
you.
hear that. Thank you.
Mr. Leary, what other explanation is there for why Mason is riding around with these people who are shooting at Mr. Clinkscale, other than it's because of Clinkscale's testimony against Esco?
Well, I don't think there is any other evidence in the record, Your Honor. I mean, I think that there's circumstantial evidence, certainly, that he was in the car and that the government tried to argue, and argued successfully, that the point of his driving the vehicle, or being the wheelman, was to retaliate.
So let's suppose defense counsel had all this information and had impeached Clinkscale, that he's not telling the truth about these particular incidents.
Well,
But I still don't know how you get around this. He's still in the car, driving the car, chasing this guy while they're shooting at him.
well,
And I admit, I know Mr. Latta says he thought he was going to Hagerstown.
that's what Mr. Latta testified to. Correct,
Yeah,
Your
that's
Honor.
what he testified to. But I mean, what other reasonable explanation is there for your client?
I can't answer that. I think the only thing that can be argued is that the evidence that came to trial from Mr. Latta was they were shooting for no reason. The Walmart tape, I mean, it's in the record. I mean,
They went to Walmart, what, like at 2 in the morning?
that's correct. And one of the things, I did not see the video, but my understanding from the video and the testimony that was elicited at trial was that Tank and Mason saw him, and there was no, I think they had
Well,
some
if they were
word.
shooting for no reason, why were they just shooting Clinkscale?
Well, I think that,
I mean, why wouldn't they be shooting other people? I
well,
mean,
I think that
that's the
Mr.
way their minds are working.
I think Tank, I think this unknown third person, I think that clearly was his intent.
Well, but they just happen,
And from a defense,
they just happen to isolate Clinkscale and shoot Mr. Clinkscale, who just happens to have been in the same pod with Mr. Mason, and one cell is directly above the other in a rather closed and confined environment where people know what other people are doing, particularly with snitching, and they just happen to be shooting at him. And no other motive is suggested.
well, I think that the
And the
motive,
district judge, furthermore, has looked at the evidence and said it would have bolstered Clinkscale's testimony and corroborated it rather than undermined it.
I think that the only thing that the records corroborated was that, in fact, they were together for a 10-day period in the same pod. Beyond that, I think those records,
No, I thought one cell was above the other.
well, correct, and Mr. Mason was on the ground floor. But again, the time frames here are critically important, and I think that, in my view, is fatal to the impeachment. Now, in terms of, I think a defense strategy could have been that the Tank was shooting, Mr. Latta was shooting, Mr. Mason was merely driving the
I know.
car, and there's,
You're a very experienced lawyer, and you know that anytime there's going to be a trial or anytime there's going to be a hearing, there's going to be some conflict as to particular times and everything, but that those minor conflicts, which lawyers are very good at picking at, because that's what they should be doing, sometimes those minor conflicts, which are part of every evidentiary clash, fail to dislodge larger points.
Well,
And in this case, it was their proximity and acquaintance.
well, I go back to the court asked Ms. Reisenweber about this. I think that the key part here is Klinkscale was the only witness as to intent, because Ms. Reisenweber had to impeach her own witness. And in fact, at the joint appendix at page 166, the district court directs the jury that the evidence for which you can determine whether or not Mr. Latta is being truthful today on the stand, it is not presented as evidence against Mr. Mason.
Fine, but you had a chance, I keep coming back, it is very, very rare that impeaching evidence is used as a basis for a new trial. It just doesn't happen very often, and the reason is, that you have a witness, the jury gets to observe that witness. In this case, the district court has observed the witness in the evidentiary hearing, and the witness, for whatever reason, both in the trial, in the collateral hearing and at trial, the witness hasn't crumbled. And you say, well, I'm sure it would have crumbled if we just found out these incidents. I'm not so sure, because Klinkscale was getting a deal, and that deal was brought up on cross-examination. And Klinkscale, why he hadn't mentioned it before, if there were reasons to discredit Klinkscale and for the jury to disbelieve Klinkscale, those reasons were brought up by Mr. Garrett.
I respectfully disagree, Your Honor.
I didn't expect you to do anything
I think
but disagree. That's your prerogative.
I think those records would have been fatal to Mr. Klinkscale's credibility. And Mr. Klinkscale, just so the record is clear, Mr. Klinkscale did not testify at the evidentiary hearing. He only testified at the trial. And again, there are these records, in our view, certainly prejudiced him. And I believe I'm out of time. And unless there are other questions, I would just wish the court and the court personnel a happy holiday.
Thank you.